SwayamPrabha. Digital India. Educated India.
Hello friends, welcome to the third lecture of our course on law of copyright, patent, trademark and other IP. We started with introduction, we discussed about international documents, and in the last lecture I was talking about copyright law. I said we'll be devoting 5-6 lectures on copyright. And I also said that the first task for any IP legislation is to identify the subject matter. And in Copyright Act, the subject matter has been identified in section 13. We discussed about the works which have been identified. And I also gave you the tests to determine the originality of those works. Now, after that, once the subject matter has been identified, the next thing is to understand what are the rights given to the creators. And the rights which we have is there in section 14. 14 can be said as monopoly creating provision. This identifies the various rights in favor of various subject matter. And if you look into section 14 of Copyright Act 1957, what you see is the list of rights which different subject matter has. For example, what are the rights in relation to literary work, what are the special rights in relation to computer program, what are the rights in relation to other subject matter. That is how section 14 provides you the list. Now, in this lecture, we will mainly talk about section 14. And the heading of this section 14 is meaning of copyright. You see, for the purpose of this act, copyright means the exclusive rights. I have already explained that the rights which you get in intellectual property are exclusive rights. Exclusive rights mean you can exclude others from exercising those rights. Nobody can exercise those rights without your authorization. So, copyright means exclusive rights to do or authorize the doing of any of the following acts. So, you have the exclusive right to do the acts listed there, or you can authorize somebody for doing the acts which are listed there. So, it has two aspects. You can do these activities yourself, you can authorize somebody for doing these activities. But you see in bold what I have written, these rights are subject to the provisions of this act. Here I would like to refer to, for example, section 48 of Patent Act. When we will discuss patent, I will refer to section 48 which talks about rights of patentees, or we will refer to section 28 of Protection of Plant Varieties and Farmers' Rights Act. Section 28 is right conferring provision in Protection of Plant Varieties and Farmers' Rights. It tells us what are the rights of breeders. 14 tells me what are the rights of owner of copyright. 14 of Copyright Act. 48 of Patent Act tells me what are the rights of patent holders. What is common in all these provisions is the phrase which I have written here in bold, subject to the provisions of this act. This means that the rights granted to owners of copyright, the rights granted to patent holders, the rights granted to breeders of a new variety of plant, all these rights are subject to other provisions. Other provisions are more important as compared to these rights. Other provisions are more important. And in other provisions, I will refer to some of the provisions which have to do with public interest. For example, in copyright, we will refer to section 52, maybe in one of the lectures, which talk about permitted acts. Those acts are in favor of users, and the rights granted in section 14 are subject to permitted acts. Similarly, when we will read Patent Act, we will see that section 48 is subject to section 47 of Patent Act. Section 47 is in favor of users. Now, what I want to conclude out of this statement is that the right conferring provisions, at least theoretically, are the least important provisions of any IP legislation, and public interest provisions are more important as compared to monopoly creating provisions in IP legislations. So, therefore, it won't be right to say that IP laws only create monopoly. No, IP laws balance monopoly with public interest, and in fact, monopoly provisions are least important provisions of any IP legislation. Now, coming back to section 14 of Copyright Act, as I said, the copyright means exclusive rights to do certain acts which are listed in section 14, or authorize somebody to do one of these acts which are listed in section 14. And as I also said, for different subject matter, you have a separate list. So, meaning of copyright for literary work is what? There are 5-6 rights. These rights mean copyright for literary work. The list of rights will be different for the owner of cinematograph film. The list of these rights will be different for sound recording producers. So, what I mean to say is copyright means many rights. So, first observation is it is a bundle of rights. Second, this bundle will have different rights for different subject matter. So, therefore, the meaning of copyright is different for different subject matter. Try and understand, because copyright is bundle of rights, and because this bundle contains different set of rights, so what we can conclude is meaning of copyright is different for different subject matter. Further, even if the rights are same, for example, reproduction right is one right which is given to all the subject matter, for example. Now, the same right has been given to all the subject matter, but still the scope of this right will vary. It is a very extensive right with respect to literary, artistic, dramatic and musical works, whereas it is not that extensive with respect to producers of cinema and producers of phonogram. So, therefore, on the basis of whatever you see on this first slide, what I want to conclude is that the meaning of copyright is different for different subject matter. So, we will move ahead with two understandings. One is copyright is bundle of rights, and second, because this bundle will have different set of rights for different subject matter, therefore, we want to conclude that meaning of copyright is different for different subject matter. There are two methods of understanding section 14. One is we read what all rights are given to literary work, what all rights are given to artistic work, and that is how we move according to subject matter. Or alternatively, we can identify the list of rights, we can understand the nature of rights, these rights, and then we can go back to section 14 and see which subject matter gets what all rights. According to me, there are these many rights: reproduction right, distribution right, commercial rental right, public performance right, broadcasting right, adaptation right and authorization right. Out of these, authorization right is not to be found in the list, but if I go back to the previous slide, I said you can do all these activities yourself or you can authorize somebody for doing these activities. This actually means authorization right, right? So, the list may not contain the word authorization right, but this is one of the rights which come out of section 14. We have to understand meaning of all these rights: reproduction right, distribution right, commercial rental right, public performance right, broadcasting right, adaptation right and authorization right. As I have already mentioned, different works will get different set of rights. So, what kind of right depends on the nature of the subject matter. I have already mentioned, even if the same right is given, it may vary in terms of the scope. All these rights which we are calling as copyright are economic rights. I mentioned about it in my first lecture that in addition to economic rights, the copyright laws will also talk about certain moral rights. For example, under Indian law, we will discuss later on in section 57, there are two moral rights recognized. One is called right of paternity, the other is called right of integrity of the work. I mentioned it in the first class. The right of paternity means that my work must be known by my name. I have a right to claim authorship of the work. Integrity right means that nobody can mutilate or distort my work to an extent that my reputation is harmed. These rights are not economic rights. These are called as moral rights. Under Indian law, these are called as special rights. There is another point of difference between copyright and moral rights. We'll understand it more later on. Copyright is granted to owners. All these rights are granted to owners of copyright, whereas moral rights are granted to authors. Maybe in the next lecture we will discuss about ownership and authorship, and we will see that it is not in every case that the author is the owner. There may be certain circumstances where I may be the author but I am not the owner. For example, if I prepare a question paper for my university, I am only the author. University becomes the first owner of the question paper which I prepare. So keep in mind, copyright is granted to owners and moral rights are granted to authors. Keep in mind that these rights will be different for different subject matter, and what rights are given will depend on the nature of the subject matter. Even if the same right is given to all the subject matter, the scope will vary. These are economic rights. Another important point is these are based on the notion of strict liability. These are based on the notion of strict liability. What I mean by that? It means that absence of knowledge on the part of defendant is not a good defense. I cannot say that I did not know about existence of copyright in the work which I am using. I cannot say that I did not intend to commit infringement. Lack of intention, absence of knowledge, I had no reason to believe that I am violating somebody's copyright. All these are not good arguments. If violated, I am liable, and my liability is based on strict liability principle. There is a general observation. I believe that copyright law has evolved against the external pressure of technology. When we did not have any means to copy, we did not have copyright. With the advent of printing press, when duplication of manuscripts became a reality, the authors and the the stakeholders started claiming protection against unauthorized duplication. So because of the invention of printing press, the technology of printing press, we came out with right to print, reprint. As new methods of recording devices came, we had to change our right. As new modes of communication came into existence, we had to change our list of rights. We had to change the law. I mentioned about the two internet treaties of WIPO. WIPO stands for World Intellectual Property Organization. If you recall, I mentioned about two treaties. One is called WIPO Copyright Treaty, the other is called WIPO Performances and Phonograms Treaty. These two treaties have been made only to address the issue of impact of internet on copyright. So as the technology is changing, we are responding to the changing technology, and therefore I conclude here that the list of rights and copyright law generally has evolved against the external pressure of technology. We will understand this statement more in our later lectures. So this is the list of rights, and now we will try to understand the nature of these rights. The first is reproduction right. This is the oldest right. This is one right which is given to all the subject matter. I have been saying that the scope will vary depending on the nature of the subject matter. Reproduction right means right to make copies, and the name of this subject, copyright, also indicates that the key word here is copying. Right to copy, or right over copies, or right against copying, right to stop others from making. So therefore, copyright for a layman will suggest that it is the copying which is the key word here. But I will tell you later on that copyright law today is not only concerned with copying. However, that still is an important concept. Therefore, the first right which we are discussing is reproduction right. As I said, it is oldest, it applies to all the works. I have the right to reproduce my work means I can stop others from making any kind of copy. Copy can be permanent, you see, copy can be permanent, it can be temporary, transient, it can be an identical copy, it can be a non-identical copy. Even if it is stored in the computer memory for a short period of time, it still amounts to reproduction. Now, in online medium, what we do? Whatever you see on your screen is temporarily stored in your hard disk. You are reproducing without taking permission, so you are violating many rights. We will see as to whether it amounts to violation or not. Kindly keep in mind that this is one kind of copying which we will again discuss in section 52C. We will come back to this point again. So, here what we have to understand that reproduction right is a very extensive right. It can be used by the owner to stop others from making any kind of copy, permanent, transient, identical, non-identical, any kind of copy. You cannot make unless you have my permission. In the year 1710, I mentioned in the first lecture, in the year 1710, the first modern legislation called as Statute of Any comes. In Statute of Any, the right which was given was right to print and reprint. Right to print and reprint has two implications. Right to reprint, as the name suggests, is printing it again. So, it means identical copying, and it means copying made by the technology of printing press. You see, it has a context. Why did we create this statute in England? Why did we pass this statute? Because authors were apprehensive about unauthorized copying by printing press. Now, in order to protect authors from unauthorized copying by printing press, the right given was right to print, reprint. Only the author can decide whether, only the owner can decide whether he wants to print or reprint. Nobody can print or reprint. Now, what I am trying to say is this word indicates two things. One, reprint means you can stop others from making identical copy only. And reprint means you can stop others from making identical copying by using the technology of printing press. So, if I am making a non-identical copy, I am not violating your right to reprint. Or if I am making a copy by employing technology other than printing press, I am not violating your right to reprint. As technology progressed, maybe in the beginning of 20th century, we started realizing that there are new methods of copying. In today's context, you have many methods of copying. There are photocopying, there are fax machines, there are digital copying, you scan it. All these cannot be stopped unless you change the word reprint. So, we started looking for a technologically neutral word which will enable the owner to stop any kind of copying by any technology. And one such word was reproduction right. So, in 20th century, in the beginning itself, we started using the word reproduction right in place of right to print, reprint. The advantage is reproduction can be identical reproduction, it can be non-identical reproduction. You do not copy the whole of it, you copy part of it, still you are violating a reproduction right. But if you are copying part of it, you are not violating right to reprint. The second is, it is technologically neutral. You copy by whatever means, whatever technology, it still amounts to violation of reproduction right. So, with the use of reproduction right, now we understand that the owner of copyright can stop others from making any kind of copying by employing any technology. But that raises another question. Identical copying will definitely be infringement. What about non-identical copying? What should be the extent of copying which is permitted? Say non-identical copying is bad, but that does not mean that I cannot take any portion from your article. I can use a portion from your article, definitely. And whatever I create becomes a non-identical copy because part of it has been copied, remaining is mine. Whether it amounts to infringement, what is the extent of copying allowed? These are difficult questions to solve. In our discussion on infringement, we will discuss that copying is not bad. It is substantial copying which is bad. So, we will talk about the concept of substantial copying later on. And that concept is important because now we are prohibiting others from making non-identical copy also. This is the meaning of reproduction right. But I said the scope will vary with respect to different works. The same right is given to producer of sound recording and producer of cinematograph film. These categories I already mentioned in my previous session. These categories may be called as entrepreneurial works. And if you recall, originality is not a requirement to give protection to sound recording and cinema. Why? Because we understand that these cannot be original. If originality means creativity, these cannot be original because what belongs to producer of sound recording? Only the recording. The content belongs to content creators, the lyricist, the composer, the musicians, the performer, the singer. Similarly, what belongs to producer of a cinematograph film? Only the recording, the shooting, the screenplay, the dialogues, the tunes, the acting. It belongs to many other people. So, since they own only the fact of recording, what reproduction right will protect in their favor? Only the recording. The content of film, the content of sound recording per se does not belong to producer of sound recording and producer of film. I said only the fact of recording belongs to them. So, if I am making a remake of the cinema, traditionally if I make a remake of a cinema or if I make a sound recording which is sound alike sound recording, but I am not copying the recording from the original sound recording, or I am not copying the recording of original cinematograph film, I am not violating your reproduction right. So, remakes can be made without taking permission of the cinema producer. What I will have to do? I will have to hire the artists, I will have to hire all the people who own content, ask them to assemble in my studio, reshoot the film, I will pay them money. I need not pay money to the original cinema producer because I am not copying his recording. The same right given to literary owner, dramatic owner, artistic owner is very extensive. It stops others from making any kind of copy. And the same right with respect to producers of cinema and sound recording is very superficial because it will stop you only from copying the recording, not the content. Remakes are allowed. Therefore, if you see, reproduction right in relation to films and sound recording is confined to the reproduction of the recording, nothing else. The content belongs to content creators. It's a very superficial right for them. If they cannot stop people from making remakes, it is of very limited use. It is only when I am copying and pasting that I am violating. As long as I am not using the recording, I am not violating their reproduction right. Now, in relation to this aspect, there is one important point which I would like to discuss. There are two approaches in relation to reproduction right for cinema and sound recording. One is called medium based approach, the other is called content based approach. There have been cases, for example, Star India Private Limited, you can see Star India Private Limited versus Leo Burnett India Private Limited, 2003, Bombay High Court. Again, there is a case Z Entertainment Enterprises Limited versus Gajendra Singh and others, 2007, Bombay High Court. There are observations. It was held that cinema need not be original. There is no requirement of originality in a cinema. It is not mentioned in section 13. We have already discussed this point. And there can never be infringement of copyright in cinema which is created independently, notwithstanding the similarity. If you make remakes, this is not infringement. This was the traditional understanding of reproduction right for cinema producers. If I make a remake of your cinema, notwithstanding the similarity between your cinema and my cinema, if I am not copying your shooting, it is not infringement. Because what belongs to you in the cinema? Not the content, only the medium, the recording. This is called medium-based approach. This was the law till 2016, when Delhi High Court decides two cases. One is called Yashraj Films versus Sri Sai Ganesh Productions and others, and the other is MRF Limited versus Metro Tyres Limited. Both these cases were decided by Delhi High Court in 2016. One is Yashraj Films Private Limited versus Sri Sai Ganesh Productions and others. The other is MRF Limited versus Metro Tyres Limited. And the observation is important here. It was held that by virtue of two sections, section 13(3)(a) and 2(d), 13(3)(a) will say that any film which is copy of some copyrighted work will not get copyright. 2(d) defines the term author. It says that producer is the author. We will in the next lecture understand author is the person who creates the work. If producer does not create the cinema, how can he be the author? That was the logic. On the basis of these two provisions, the Delhi High Court says that there is a requirement that cinema must be original. Even if it is not written in section 13 as one of the requirements, it is still a requirement. It may not be expressly written, but it is still a requirement. A cinema, in order to get protection, must be original. And that comes from the combined reading of 13(3)(a) and 2(d). Court held that the right of the producer of cinema to stop others from making a copy of the film does not mean making a physical copy of the film by process of duplication. It is not just Ctrl+C, Ctrl+V which will violate the reproduction right, but it also refers to another film which is substantially and materially resembles the original film. So now in this case, court says if the defendant's cinema is materially same as plaintiff's cinema, it amounts to violation of reproduction right of plaintiff. That means these two judgments are saying that remakes cannot be made unless you have the permission of the original film producer. These two judgments tend to take us to a conclusion that even content is also protected in favor of producer. I have been saying that only the medium belongs to producer of cinema, and if the medium is not copied, the recording is not copied, it is not violation of the reproduction right of the producer. In these two cases, court said that even if content is copied, it is similar, the defendant may not have copied the shooting or recording, still it amounts to violation. So the outcome of these two judgments is that remakes of a cinematograph film cannot be made. This is called content-based approach. I will not go in detail of these anymore, but I will request the students to kindly read Yashraj Films Private Limited, because I believe that content-based approach does not seem to be in line with traditional understanding of copyright. If you go back to the definition of sound recording, section 2XX, I defined it in the last class. I said sound recording means recording of sound. I also said that sound belongs to content creators, only the recording belongs to producer. If the content does not belong to producer, how can you protect the content in favor of producer? That's a question. So I tend to believe that medium-based approach is the correct approach in order to protect the reproduction right of the producers of cinema and sound recording. However, the recent judgment of Delhi High Court is not in line with that. Further, you also see after these two judgments, Delhi High Court says there is a requirement of originality in cinematograph film. The next right in the list is distribution right. We have understood the meaning of reproduction right. We started from right to reprint to finally reproduction right, how it is a very extensive right for a few works, how it is very superficial for few works, and how the 2016 judgment of Delhi High Court changes the whole scenario, and how the content based approach has become the law now, which I think need to be reconsidered, and therefore I requested all of you to kindly read the judgment of Yash Raj Films decided by Delhi High Court. Now, the second right in the list is distribution right. Distribution right, when you will read section 14, it is written, it is not given by using the word distribution right. The language is right to issue copies to public not being copies already in circulation. I will come back to the language. What distribution actually means? Distribution means putting tangible copies in commercial circulation. Putting tangible copies in commercial circulation by selling, by giving it on hire. So, if I give copies of my work on hire, I am exercising my distribution right. If I sell it, I am exercising my distribution right. I will come back to the language. So, distribution is putting some tangible copies in commercial circulation. It is different from publication. Publication has been defined in section 3. Publication means bringing the work to public for the first time. Now, how can you bring the work to public for the first time? There are two methods. If you read section 3, it says bringing the work to public for the first time either by communication or by issuing copies. There are just two methods to bring something to public. Why? Because the word communication has been defined in section 2FF. It is not there in the slide. Kindly listen to me carefully. The word communication has been defined in section 2FF to include any mode of communication, any kind of communication. Direct communication, communication through display, communication through diffusion. Broadcasting is communication, webcasting, communication through internet is communication. So, all the forms by which I can communicate is included in the definition of 2FF except by issuing physical copies. So, entire mode of communication is mentioned in 2FF except by issuing physical copies. Distribution is not communication. Issuing physical copies is distribution. Distribution is not communication. So, if I add these two, I get all the methods. So, how I can bring my work to public for the first time? I can bring it either by communication or by distribution. I have to inaugurate my work, I have to launch my book, I can release it, I can broadcast it, I have to launch my music, I can broadcast it, I can webcast it, I can issue copies, all these methods can be used. So, publication means bringing something to the public for the first time, and distribution, now let us go back to the language, distribution means issuing copies to public. So, distribution means issuing copies to public. But you also have something written here, not being copies already in circulation. You see, not being copies already in circulation. This is called doctrine of first sale. Try and understand. Distribution right always comes along with first sale doctrine. That means my right to distribute exhausts on very first act of distribution. The moment I sell a copy of my work to you, my rights on that copy will exhaust. And how do you distribute that copy? That cannot be controlled by me. So, this is called first sale doctrine. On very first act of sale, my right of distribution on that particular copy exhausts. This is also called as doctrine of exhaustion. I will come to this doctrine of exhaustion maybe slightly later. But first of all, see what is the meaning of right to issue copies to public. Because when I am saying I can sell it, the act of sale is complete. But when can we say that the act of issuing copies to public is complete? When can we say that the act of issuing copies to public is complete? When the publisher sells it to wholesaler, is the act of issuance complete? When the wholesaler sells it to the retailer, is the act of issuance to public complete? I do not think so. When the retailer sells the copies to public, then can we say that act of issuance is complete. Now, till the time act of issuing copies to public has not happened, the owner of copyright can exercise control on the movement of work, copies of the work. Once it has come to public, once it has been issued to public, then the right to control subsequent movement of the copies exhausts. So, doctrine of exhaustion means the right to control subsequent distribution will exhaust on the first act of distribution. First sale doctrine would mean the right to control subsequent distribution will exhaust on very first act of sale. Now, exhaustion can be of two kinds. One is national exhaustion, the other is international exhaustion. National exhaustion means, now this is important, kindly understand. National exhaustion means my rights will exhaust only with respect to works published in India. If the work is Indian work, I sell it, my rights will exhaust. But if it is a non-Indian work, my rights will not exhaust. So, national exhaustion means exhaustion of rights with respect to work which is published in India, and international exhaustion means exhaustion of rights which are published internationally. Now, what is the implication? Try and understand. If I go to a country, for example, Brazil, and I purchase books from Brazil, because publishers maintain price difference. The same book in USA will be costlier as compared to its edition in South Asia or Southeast Asia or some Latin American country. So, if I go to some country in Latin America, let us say Brazil, purchase the edition from there at a less cost. Once it is sold, the rights exhaust, I bring it to India and sell it at a lower price, whereas the same owner may be selling it in India at a higher price. So, the interest of owner is harmed because of parallel trade, and this parallel trade will take place only once the rights have exhausted internationally. You cannot control subsequent movement of goods anywhere in the world. So, parallel trade is an offshoot of international exhaustion doctrine. Developed countries would not like to allow international exhaustion of rights, because their argument would be that we maintain price difference keeping in view the paying capacity of people from different countries. If you allow work to be brought from one country to the other country as parallel import, then we will stop maintaining the price difference, because that goes against our interest. Exhaustion must not be international exhaustion. That is the argument of developed countries. It must be national exhaustion only. Country like India would like to promote parallel trade both in patents and copyright. So, therefore, we will argue in favor of international exhaustion, because parallel trade will ensure that we get cheaper copies of work from some other countries, bring it to India and sell it in India. Now, this tussle between developed and developing countries led to a situation where in TRIPS agreement article 6, it is said that the dispute related to exhaustion doctrine will not be entertained by WTO dispute resolution forum, meaning thereby the country is free to have whatever kind of exhaustion doctrine they want to have in their law. We will discuss in patent law that Patent Act clearly mentions that India adopts international exhaustion doctrine so that parallel trade is possible. We can purchase the medicine lawfully from a person who is authorized to sell it in some other country. Once he sells it, his rights exhaust internationally. We bring it to India, he cannot stop me, and we will sell it at a low price. That is clearly recognized in Patent Act 1970. The same is clearly not mentioned in Copyright Act 1957. It is not clearly mentioned that we can go to some other country, purchase it lawfully from an authorized person, bring it to India, whether such a copy amounts to infringing copy or not, whether it amounts to infringement, whether it is permitted. This is not clearly mentioned in copyright law. And there have been many cases on the point as to whether India has national exhaustion or international exhaustion. Without going into those cases, I will mention few provisions which support the argument that India has international exhaustion. Section 51(b)(4), Section 51(b)(4), 51 defines infringement. Section 51(b)(4) says importation of infringing copy is prohibited. Importation of infringing copy is unlawful. Does it not mean that importation of lawfully acquired copy is valid? Importation of lawfully acquired copy is valid means parallel trade is valid, means Copyright Act supports international exhaustion of rights. Then you have two provisions here, 40 and 41. Try and recall. We have discussed the principle of national treatment, where we said that country A will give same protection to works of country B which it gives to its own nationals. India will give same protection to works of Indians which it gives to works of England. Now, if the rights will exhaust with respect to Indian works by virtue of these two provisions which incorporate national treatment principle in Indian law, we should give same protection to foreign works. If rights with respect to Indian works exhaust on first sale, then rights with respect to foreign works must also exhaust on first sale. This is what we can derive from the principle of national treatment, because we cannot discriminate, we are not discriminating. If rights are exhausting with respect to Indian works, it must also exhaust with respect to non-Indian works. And that is nothing but international exhaustion of rights. So therefore, on the basis of these few provisions, I am trying to argue that even if we do not have it in our definition of infringing copy in section 2M, you see in 2M, in the year 2012, when we were amending Copyright Act, we tried to mention that parallel trade is allowed, but this did not ultimately happen. So therefore, there is no clear mention in the Act whether Indian Copyright Act supports national exhaustion or international exhaustion. But by virtue of these provisions which I mentioned here, one can argue that India has got international exhaustion doctrine. So that is about distribution right. The right is to issue copies to public, not being copies already in circulation. Not being copies already in circulation means you do not have the right in relation to those copies which are in circulation. If I go back to my previous slide, you see the right is to issue copies to public, and then not being copies already in circulation. This means exhaustion. This means exhaustion doctrine. Your right does not exist with respect to those copies which have been issued, which have been circulated, which have been distributed. Why? Because rights exhaust after first act of distribution. So this language indicates that you have the right here and you have the exhaustion doctrine attached with it. As I already said, distribution right always comes along with the first sale doctrine. The third right is rental right, commercial rental right. Let me go back to distribution right once again. If we know that once distributed, I cannot control subsequent distribution. I cannot stop the transferee from dealing with my work the way he wants to do. Because distribution right comes with first sale doctrine, there are situations where the work is available in soft form, for example, computer program, sound recording, cinema. These works come in soft form, in digital form. And whatever work which comes in digital form can be easily duplicated. You can make multiple copies without reduction in quality of the work. You can make multiple copies without reduction in quality of the work. So therefore, you want to give a right to the owner, after exercising which he can retain some control over the transferee, so that he can have an eye on the transferee that he is not making unauthorized works. So instead of giving distribution right, it is wise to give commercial rental right to the owners of those works which come in digital form. Now, if you look into section 14, the owner of a computer program, owner of a cinema, owner of a sound recording have been given commercial rental right. Only these three categories have been given commercial rental right. Why? Because these come in digital form, duplication is easy. In order to allow the owner to retain right, give them commercial rental right. So now a computer program owner will not like to exercise distribution right. Instead, he would like to exercise commercial rental right. He would like to give his computer program on commercial rental, so that he can control subsequent movement of the computer program. Copy of cinema will not be sold. Copy of cinema will be given on commercial rental, so that subsequent rental can be controlled. So therefore, commercial rental right is a new right which emerged because of TRIPS agreement, and this is given to those works which come in digital form. The meaning of commercial rental is there in section 2FA. It clearly says that it does not include lending. So element of commercial rental means if you give something for free, that is not commercial rental. Further, any act of giving something for free by non-profit library will not mean commercial rental. The name itself suggests that this is not something for non-profit purpose. Now therefore, this part is important. This right is important because distribution right may not be very important in digital context, because it comes with first sale doctrine, and therefore commercial rental right assumes importance. The next right is public performance right, and the key word is public. If you are performing my work in public, you are infringing my public performance right. If you are performing my work in public, you are infringing my public performance right. When can you say that you are performing my work in public? There are simple cases. For example, if you perform it on street, you perform it on theatre, etc., it is simple to decide. But otherwise, how will you decide whether the performance is in public or not? I said the key word is public. And there are three tests to determine whether the performance is made in public or not. First test, you have a case called as Duck versus Bates. The first test to determine whether the performance is made in public or not is to see whether it is made in front of audience who share a common link. So the first test focuses on character of the audience. In this case, there was a dramatic performance done in a hospital for the nurses of that particular hospital. Court concludes that this is not public performance because the audience, nature of audience is such that every single member of audience is connected with a common link. If all the members of audience share a commonality, then that audience does not become public. This is one test. For example, if I have a room where I have installed a television and a set-top box, set-top boxes are meant for private performance. Now, if I have installed a set-top box and that room is meant for the recreation of my employees only, then I can argue that all the members who visit this room, all the audience share a common link, and therefore all the members, the audience is not public. So first test focuses on nature of audience. The second test will focus on financial considerations. This is not a very foolproof test because you may come to a wrong conclusion, because this test will focus on financial consideration, whether the performer is paid or not, whether there is entrance fees for that. If it is a paid performance, if you are asked to pay for entering into the hall, all these considerations, all these factors would mean that it is public performance. And the third will focus on copyright owner's monopoly. Third will focus on copyright owner's monopoly. There is an artist. I am suppose not the audience of an artist A. I don't like his performance. I don't like his songs. And there are 100 people who don't like his song. If you perform his music in front of people like me, you are not performing it in front of his monopoly. And such a performance would not mean public performance. So this test will focus on copyright owner's monopoly, whether the audience is actually the audience of that performer or not. And if that is not the case, it is not violation of public performance right. As I said, the first test is most objective, which focuses on the character of the audience, as we have discussed the case of Duck versus Bates. Next right is right to broadcast the work. Broadcasting emerged in 1920s, radio broadcasting emerged in 1920s. 1927 there is a judgment called as Messenger versus BBC, where BBC broadcasted private performance and a case of violation of broadcasting right was filed. Court recognized that content creators, the performers, have a distinct right, a new right called as right to broadcast the work. As I have been saying, the copyright law has been evolving against external pressure of technology. When this new technology of broadcasting started, we gave a new right to the content creators, that is to broadcast their work. An important question here is, what is the place of broadcast? Broadcasting has been defined in section 2DD. It means wireless broadcasting, wired broadcasting, even rebroadcasting is broadcasting. What is the place of broadcasting? Because place of broadcasting is going to play an important role in deciding where, in which country you are violating the right. There are two theories. One is called emission theory, the other is called reception theory. Emission theory says the place from where you are uplinking the signal is the place of broadcast and you are amenable to law of that country. But if that country does not have TRIPS compliant law, then in that case we will apply reception theory, which says that all the countries where your signals are being received will become place of broadcast and you will be amenable to the jurisdiction of courts of all these countries. So mainly emission theory is going to be applied provided the country from where you are emitting your signal has got TRIPS compliant law. Adaptation right. Right to adaptation would mean changing the form in one way. We will understand when we will discuss infringement that adaptation and reproduction by changing the form are overlapping rights. Reproduction right means reproduction by taking apart, reproduction by changing the form. So I convert a novel into cinema, I am violating the reproduction right of the novelist, the owner of copyright in novel. So adaptation right and reproduction right, reproduction by changing the form, seem to overlap. Adaptation in relation to literary work, there are examples given in section 2. If you dramatize a non-dramatic work, it is adaptation. If you convert a literary work into a comic strip, it is adaptation. If you change the language of a computer program, that is adaptation. So adaptation right, again a very old right, but it seems to overlap with reproduction right and is not used that often. The last right in this list is called authorization right. If you recall, I said it is not expressly mentioned in section 14. However, by the fact that whatever you can do yourself, you can authorize somebody else to do it, means there is a right called as authorization right. Anybody who is making facility for doing something which he himself is not allowed to do would mean he is violating authorization right. For example, I cannot photocopy your work. Second point, I cannot provide photocopy machine in my library so that others photocopy it. So, if I am photocopying it, I am violating your reproduction right. If I am providing means to photocopy your work without your permission, I am violating your authorization right. Internet service providers do not violate rights. They connect you to internet and in the process you violate those rights. So, ISP is not violating your reproduction right. ISP is violating your authorization right. ISP cannot authorize others for making copies of your work. It is you who can authorize. Let me briefly tell you, when Sony Corporation came out with the double deck machine, people said that Sony Corporation, you insert two cassettes, make one cassette from another cassette. It was argued that Sony Corporation is violating authorization right, where it is authorizing making copies which only the owner of copyright can do. So, these are the rights. In the present session, we learnt about the rights, we learnt about section 14. As I discussed, there are certain rights which are overlapping, reproduction and adaptation. I said that there is one issue which is not settled, which is the difference between content based approach and medium based approach. I requested you to read the case of Yashraj Films and make an opinion. So, after discussing all these, in the next session, we will talk about the concepts of authorship and ownership. We will refer to section 17, we will refer to section 2D, and thank you very much for attending the session. Thank you.
Hello and welcome to this piece of literary snippet. Perhaps the most popular literary genre after novel is the short story. Sharp, compact narratives whose charm lies not only in what is said, but also in what remains unsaid. Today I will be reading one of the shortest instances of a short story that I have ever encountered, and indeed the very charm of this particular story that I am going to read out today lies in the way it abruptly ends. It is an ancient tale from Mesopotamia which has been retold by several authors, among whom the name of Somerset Maugham stands out. The adaptation that I will be reading out is perhaps the closest to the one that Maugham wrote. The story is titled, in all of its adaptations almost, as Appointment in Samara. Here is the story. A merchant in Baghdad once sent one of his servants to the market. The servant was supposed to buy provisions for the merchant, but when he returned, he came back empty-handed. Indeed, the servant had all gone white, and trembling with fear, he told his master that he had met death in the marketplace. When I entered the market, the servant said to his master, I was jostled by a woman, and when I turned to look at her, I saw that she was death. I am very scared, master, because death looked at me with a threatening gesture. Can you please lend me your horse so that I can fly away from Baghdad to the town of Samara and thereby escape death? The master, being a good man, gave his servant his best horse and saw him gallop off to Samara to escape death. Then the master himself went to the marketplace and confronted death. Why did you make a threatening gesture to my servant? Asked the master to Death. And Death replied, it was not a threatening gesture. Rather, it was a start of surprise. I was astonished to see your servant here today, because this evening I have an appointment with him in Samara. See you in the next episode of Literary Snippet.